Welcome back to Legalese. In this particular topic, we're going to get a little bit more substantive. We're going to talk about wills. We're going to talk about trusts. My name is Ryan Peabody. This is my colleague, Greg Treat.
Hello.
We're practicing attorneys here in Southlake, Texas, and we do a tremendous amount of estate planning. We do hundreds of wills, hundreds of trusts, and we're going to get into the main question I get more than anything else is, when do I need a will? When do I need a trust? And then, of course, what are these documents? So I'm going to go ahead and jump right into it. We do estate planning when I sit with a client for the first time in two parts: the wills and the trusts and the powers of attorney. Powers of attorney are like medical power, statutory durable power, which is like your financial power of attorney. Guardianship for the kids is kind of in that same category. We're actually not going to talk about that just now. We're going to talk about that in a later episode, so look for that. But right now, I want to talk about what I refer to as the meat and potatoes, which are wills, which are trusts. When do you need them? How are they structured?
Yeah, so when we get clients in, they're coming in for a variety of reasons. Many times will have an old estate plan. They'll have some kind of, though oftentimes we'll get people that have never had any estate plan. You'd be surprised at how many people have just never sat down and gotten a will.
Yeah, that's
and they come to us and they say, do I need more than what I have?
Yeah, that's a great point. So 80% of Americans have never done estate planning before. If you've never done estate planning before, and what we're talking about is when you die, right? But you want your family legacy and the inheritance to be preserved. Maybe many of you have inherited from your parents or grandparents in your life. And if you have nothing, your heirs will get your inheritance, but it's going to go by statute. And it's going to go through probate. Probate is a Latin word. It means proving up. It is for people that need to go to the court system to verify that all the assets go to the kids or go to the spouse or wherever they go. Maybe you have a charity on board and they go there legitimately, and it transfers title with titled assets like, real property, a house or, sometimes a vehicle. Mm-hmm. In Texas, it's a little easier to transfer a vehicle, but it's still a titled asset. And you need the court to sign off on a lot of these things in order for that to have marketable title and for it to go to the beneficiaries, which are the inheritance of the stuff that you've built up, the stuff that you made. My clients don't go to probate unless they need to go to probate because they came to me afterward and their family was unprepared or something like that.
Right.
We don't want to go to probate.
Yeah,
probate
that's the goal.
is, to put it bluntly, it's a pain in the butt. It's expensive. It is public. And it takes a long time. I mean, we've had probate cases that have gone well over a year because they're complex and a variety of factors. So we don't want to go through probate if we don't have to. Keep the money in your pocket instead of paying the attorneys and paying the court and paying experts and everything else that we need to do to properly get an estate passed from one generation to the next.
Yeah, and that privacy issue is a huge issue. One of the things that we talk to people about is go to an identity theft protection website, something that explains the kinds of things you need to make sure are not in the public view, and then go and look up any probate case, get a hold of a probate file and see what's publicly accessible for somebody else and say, and look at those two documents. What would you need to lose your identity and what the probate court has to publish by law? I mean, this is not the courts doing something improper. This is how the state laws are constructed at this time.
Yeah, so let's keep things simple here. What is a will? What is a trust? Mm-hmm. What these are is they are contracts that typically go into effect upon your passing. I know we're talking about death, but what we're really talking about here is the preservation of family wealth. We're taking care of kids. We're making sure kids aren't getting a massive inheritance at 18 years old, for example. So what is a will? A will is a contract, and it identifies just a couple of very basic categories. Who you are, what the structure of your family is. So are you married? Do you have kids? It identifies who they are in there, and where you want your stuff to go to, who you want your stuff to go to by category. Personal property, real property. Personal property is pretty much everything that is not dirt. Mm-hmm. All right. If it's dirt, it's real property. If it's cash money, if it's gold, if it's a vehicle, if it's household furniture, if it's a collector's item, it's personal property.
Clothes.
So it's just those two categories. Yeah, everything. And if you have a simple will, then your beneficiaries are going to be most commonly your spouse followed by your kids. That's most common. If you are utilizing a trust in addition to a will, the trust goes from a simple, straightforward, or the will rather, goes from a simple, straightforward will to what's called a pour-over will. So the only difference is you identify yourself, your family, your stuff, and then who it goes to is that last thing. And who it goes to in a pour-over will is the trust. There are two types of trust. There's a revocable trust and there's irrevocable trust. A lot more complexities to it, but what we're talking about right now is a revocable trust. Revocable means changeable. So if you have more kids down the road, you can add those to a trust. You can do a trust amendment and update that trust. And if it's drafted properly, it's an easy thing to do an update. It's the same with a will. A will update's called a codicil. You don't need to know that, but it is an update to a will. So most of our clients ask me, when do I need this stuff? Mm-hmm. And we like trusts because they're a really good vehicle. So basic, simple wills are for people, and I'm going to give broad generalizations here, but typically they're for people that do not own real property. So they don't own a home. They're probably renting somewhere. Oftentimes they don't have children. They're not married. They're single. They don't have a lot of money. That's where a simple will is just fine because it's an easy probate process, even if they do need to go through probate. There are smaller mechanisms, or I should say not smaller, simpler mechanisms to go through probate if you just have a simple will. So, but for most people, for most of our clients, most of our clients own a home, they're married, and they've got kids. And they have various levels of wealth in between there, from retirement assets, life insurance, to home. And maybe they own a second property or a rental property.
Many of them own businesses.
These sorts of things. We always like to recommend a trust in those circumstances because everything is about protecting the family and protecting the kids. So if children get an inheritance because something happens to mom and dad, getting an inheritance is not winning the lottery. And I've seen it so many times where it's treated like winning the lottery, intentionally and unintentionally. And let me talk about that. So if an 18-year-old gets $500,000, $1 million, sometimes more money just dumped into their lap at their 18th birthday because mom and dad didn't have anything in place, now that money's in their checking account. And what do they do with that money? They go down to the local sports car dealership and buy a Porsche or buy a Mercedes or something expensive.
Always.
They're not taking into consideration anything. Time, value, money, opportunity costs, investment of that inheritance, using the money to preserve their legacy, to buy a home, to pay off debt, the good stuff. They're not doing it. And for them to make that mistake, inheritance is a one-time deal.
Right.
So once they make that mistake, it's done. So oftentimes what we'll do is we'll have that money pour into a trust, and somebody will manage that money on their behalf and feed it out to them over the course of time. So we'll give them maybe a 25% or even a third of it after they finish college, maybe kind of around that mid-20s mark, and then feed the rest of it out to them over the course of the next 5 or 10 years, 30, 35 years old. And what we're going for here is maturity. So we want to give people money when they are mature enough to have that money. And you may think to yourself, well, my kid's very mature. Let them have the money all at once. Here's another example of I've seen a big mistake. They don't have a lot of business experience. And I've seen, I have one client in particular. He was a young guy, early 20s, and inherited several $1 million. So a friend of his came to him and said, hey, well, let's start up a company together. And let's take the money that you have and let's put it all into this company and we'll grow it together and it'll be great. A year later, all the money was gone. He was broke and the company was out of business. He didn't intentionally go out and spend the money on things that were frivolous.
Yeah, he did the best he could.
But he lost it anyway. So to give that money to them over the course of time, hopefully they're learning the kind of lessons. They say, oh, wow, I now have a better perspective. I'm earning my own money. I've got my own family. I know how to preserve wealth. I know how to interact with money because I have a better perspective over the course of time now. And that's where a trust really, really pays dividends for you and your family.
Well, and it doesn't just have to be age. We can also set up milestones, or if things happen to you. One of the common things is graduating from college or a trade school, or reaching a certain educational milestone. We can tie money to that. We tied money to getting married, to having children, things of that nature.
But it's all about age and experience. So if you dump money into the lap of somebody that doesn't have a lot of age and experience, it's a higher likelihood that they're not going to use it appropriately.
Right.
So what do? How do we solve this? We throttle the amount of money they get over the course of time by utilizing a will and a trust combination. So if it's a revocable trust, they don't have access to it until mom and dad die. But when mom and dad do pass away, that revocable trust then converts into an irrevocable trust. And that's when it's paying out money to usually to your kids in a manner that you and a good attorney can set up and structure. Don't over-engineer it, and make sure you're taking in tax considerations and all these things that a good practicing attorney will know, or they should know.
Or at least know enough to contact the CPA.
Yeah, if it's a taxable event, but that's typically going to be good for most people, that combination.
So one of the key players, obviously, in a trust is the trustee. So we oftentimes will talk to people about how to select the trustee, who this person is. So what do you tell clients when you're talking to them about who their trustee is going to be?
If we're talking about the same thing we've been talking about, the living revocable trust, and I use the word living, I don't really like that term, but it's out there and you may have heard that. What they're just referring to is a revocable changeable trust. And so if it's living, it means changeable, it's modifiable, you can evolve it over the course of time, add provisions, take provisions away, that sort of a thing. So it needs to have the flexibility to do that. You need to have a relationship with an attorney that can build those relationships. But ask me that question.
In a revocable trust, obviously the initial trustees, as you always say,
right. The
initial trustees are the grantors themselves. But then who do they select?
Okay. So in a revocable trust like we're talking about, thank you, Greg, for getting me back on topic. Your typical trust in this circumstances is mom and dad, okay, the husband and wife team, which that's what it is, or it's an individual, it's just you. You are the grantor, you're the creator. Sometimes the settlor is a term that's used, or the testator. It's all the same thing. We like to use the word grantor. That's the person who it's your stuff, it's your trust.
Right.
We may be drafting it for you, but you're the one creating it. And you're also the trustee, or if husband and wife, oftentimes will be co-trustees of that trust. So you have full and unrestricted access to all of your stuff. The trust is kind of sitting in the background. It's waiting to go into effect, but you're the co-trustees. And then you're also the beneficiaries because it's your stuff. And your kids are the successor beneficiaries. So they will be the beneficiaries at some point for most people. But you also want to have a successor trustee. That's going to be the most important role. If you've got minor children, you want a successor trustee that is somebody that you trust, that's not going to misappropriate funds, that's going to make sure those funds from your estate are invested properly. And if you need to hire a wealth manager, you do that. You need to interact with an attorney or a CPA. That's the person that hires it. That's the person that gives the money out to the beneficiaries over the course of time in an appropriate manner. And by appropriate manner, I mean however we have designed that trust with you in order to match the specific needs of your family and your kids.
Right. Well, let's say you have a particular financial manager, CPA, that you want involved in the process of managing the money after you pass. Can we put that in? People will obviously ask us, can we put that in the trust? We get that frequently.
Yeah, we certainly can. If you have somebody in your family that is that does that type of work, or if you have somebody that you know that's been managing your money for a long time, yes, we can definitely name those. And then we like to give flexibility to the family to be able to modify or to move that person around. It's very custom, very tailored to each family. If a trust is being sold to you as generic or one size fits all, or it's just boilerplate, turn around and run the other direction, because that's not what a will is. That's not what a trust is. It should be custom to your needs.
Right. And obviously there are things called testamentary trusts, and there's people that the way they do estate planning is they'll have one document that's a will and testamentary trust. And we prefer to have that document as two separate documents.
Gosh, Greg,
talk about that?
Yeah, I'm really glad you actually brought that up. I was not thinking of that just now, but oftentimes somebody will think that they have a trust when they really don't. So it's called a testamentary trust, right? Mm-hmm. And so it's just a will. And inside of that will, it says something along the lines of, and they're all different, A trust will come into formation upon your death if your kids are minors. That's the most common times we see a testamentary trust. And so what happens essentially is that it's still going through probate. And then at the end of probate, a very simple bank account is set up that's a trust account, and that all the money goes into, and then that's the testamentary trust. There's no language that goes along with it. There's typically not much of any direction that goes along with that testamentary trust. And it's really not a good solution, in my opinion. A much better solution is to have a standalone trust, have it ready, have it built out, have it as a waiting vehicle. So we start titling assets in it now. We're not going through probate. We're saving the money. It's private. We're in some instances we're even avoiding taxes, not evading taxes, but avoiding taxes, and it's all ready to go and it's not a mess. Right. So if you have a trust inside of a will and you fit the profile that we're talking about, you own property, you got kids, you need to take a really strong look at having a separate trust and not a testamentary trust. They're okay. I've seen them work out fine. I don't like them. I think they're ineffective.
And they don't avoid probate.
They don't avoid probate. And the largest problem with them is that there's just so much uncertainty with them, and they just don't serve a very good purpose.
Right. With the
but they're cheaper, though. That's why people do them.
Indeed.
They're cheap to do. And if you cheap out now, fine. Your kids can go ahead and pay tens of thousands of dollars later to get it fixed.
Well, right, because the idea of having a live trust is there's things in that trust, they don't go to probate. If you have a testamentary trust, there's nothing in it. Now, it'll get created eventually, but you've got to go in front of the court. If there's any struggles in your family, if there's any issues, then everything's up for grabs at the outset before any assets are able to be distributed. If you have an existing trust, then the trustee is free to move forward, to do what's proper and appropriate, and to start, bringing out people's wishes. Someone else has to haul you into court. You don't have to go into court ahead of time.
Yeah, and what we're talking about here, we're not talking about what you would see in like a movie or a television where someone is a trust fund baby, right? That's really not what we're talking about here. That's a very different and separate conversation that we would need to have. We're just talking about avoiding the court system, avoiding putting your assets on publicly, getting the assets to your heirs as efficiently, as quickly as possible. That's what a pour-over will and a revocable trust do. It is a fantastic mechanism for anybody that's got wealth under, let's call it if they're a married couple, under about $20 million. The lifetime exemption, which we will not go into right now, is above that. It's about $23.5 million or $11.58 million per person. So 99.9% of Americans, as you know, are below that limit.
Yeah.
We certainly service those clients. They're uncommon. But most people, they own a home. They've got some retirement. They got some kids. A will trust combination, in my opinion, as a professional, is the way to go. That's what I do for my family. That's what you do for your family.
Yep, that's what I've done for my family.
That's the proper way to go, and it's really not that expensive. If you're cutting corners in this area, there are other places in law or in your family structure where you can legitimately save money. You may not need to spend it. This is really not one of them. Right. So it's well worth the investment, and these are documents that are meant to grow with you and meant to kind of partner alongside of you through many, many years.
Yeah, well, and that we're talking about having a structure that is private, and it looks like a lot of money up front sometimes, but it really is the best way to get across what you want to get across. If you're, in addition, if you have a more complex family situation, if you have one of your children has some struggles, then the trust structure allows you to dial in exactly what they need or what they don't need.
And it's not complicated to do that.
Right.
This basic structure is still what we like to use. Now, if it goes off into the weeds and we have a special needs family member, that's a different discussion topic. We can go into that in a later episode. Certainly, we do a lot of that type of work. Or if it's some kind of a specialty trust, that's fine. But what we're talking about is the basics that applies to most family that fits the profile that we discussed here.
All right. So is there anything else that you would add on the topic of wills and trusts?
Talk to a professional. You get what you pay for. Talk to an attorney that practices in this area. Be very careful. If they practice in multiple areas or they practice in a specific area that's other than estate planning, just ask them those questions. How many of these do you do a year? How often do you do estate planning? And they should be able to give you answers. An attorney should be able to give you answers that indicates that they do a lot of this type of work and they can answer all the questions off the top of their head. They've got the right experience. That's who you want.
All right. Thank you so much for listening to this episode of the Legalese Show, and we'll see you next time.
See you next time. Thanks.